Hello everyone and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to our speakers to get us started.
Thank you, Mona. Hello, everyone, and thank you for joining us. I'm Nadia Nicolaou, subject matter expert in litigation arbitration at Opus 2. Before joining Opus 2, I was a practicing solicitor in London, specializing in litigation and arbitration. In the next 45 minutes or so, we will discuss the AI's impact on litigation teams and how to get a head start in the race to win your case. We will have time at the end for questions and answers. Today with us, we have James Beaker and Raymond Benting. I will let them introduce themselves. James?
Hello, everyone. I am James Beaker. I am the Director of Litigation Services. I'm going to apologize a little in advance. I have a little bit of a slight black eye. I had a kid kick me in the face this weekend. Nothing interesting like a bar brawl over the Dodgers or anything, but unfortunately, they don't have a very big hair and makeup budget for these things, so I couldn't cover it up. Anyway, I'm the Director of Litigation Services at Baker and Hostetler, and I'm looking forward to this panel.
Thank you, James. Raymond?
James, I can't even see your black eye, so I wouldn't be too worried about it. Hello, everyone. My name is Raymond Benting, and I'm the Chief Product Officer at Opus 2. Prior to Opus 2, I worked on several AI projects in many industries, from financial services, distribution, manufacturing, life sciences, and others. Within legal, I've also worked with law firms around areas such as intelligent information retrieval, with natural language processing and automatic document classification and coding. These technologies were the predecessor to knowledge management and eDiscovery technologies. And I've been with Opus 2 for nearly 8 years now.
Thank you, Raymond. So, generative AI took the legal world by storm. I don't want to exaggerate, but it was the hottest topic in 2023, and it still is. And 2024 is almost over. Is it a fad or is it here to stay? Let's see what our audience thinks. Muna, could you please share the first poll question for the audience? We would be interested to hear, what do you think? Is generative AI a fad or is it here to stay in the legal sector? Thank you, Muna. So whilst we wait for the audience to reply, what do you think, James? Any trends you have seen that are worth mentioning?
I definitely, in my opinion, don't think it's a fad. It's here to stay, and I think it's it's for the better. I mean, things keep changing in our world, and we have to adjust to them. And this is just a new technology that we can adopt. So what I'm seeing is a lot more clients are asking about it, and a lot more clients are asking questions and asking how we're using it. So there's, risk balancing we have to do and concerns about how we're using this technology. So I see that it's a very, very a big topic of interest that is very important to most of our clients. And some love it and some don't want us touching it. So it depends on each one differently, and we have to analyze it for each case and each client to figure out how or if we should be using it for their matters.
Indeed. What about you, Raymond? Do you agree or have you noticed something different?
Well, I think it's no surprise that I agree Gen AI is not a fad, and I don't believe it will replace lawyers, which is another question that I get asked quite a lot. We have seen this before with other technologies. Before eDiscovery, for example, there was a lot more manual review of documents. Then adding in eDiscovery did not get rid of the review process, it just evolved. It meant that law firms firms could review more documents more effectively. With Gen AI, we see the same will hold true. Automating certain tasks, such as finding the facts in a case, does not change the need to perform analysis around your case strategy. It just frees up time to concentrate on the more valuable tasks, such as exploring and testing winning case strategies. What we should also be, though, is honest about the limitations of Gen AI. What we have achieved with Gen AI is a solution to a problem that we've actually been trying to solve for decades. It has only been possible with the advancement in computing power that enables deep learning and subsequent analysis of information. Gen AI automates certain tasks, but doesn't replace human intelligence. Humans have memory, we have experience, we have imagination, and we can predict the future based on what-if scenarios, and we have the ability to plan and strategize. All of these are hugely important in litigation. Gen AI cannot do these things right now, and it's not clear whether Gen AI will ever be able to provide a solution around these inherent human characteristics, or whether we'll need a new generation of AI technology to assist in these areas.
Yeah. Thank you, Raymond. Let's see what the market thinks. Muna, thank you for sharing the poll. We'll come to that in a second, but let's see what the market thinks before we go into what our audience thinks. So an article in Bloomberg Law on the topic states, it's clear AI is impacting the legal profession and this technology is here to stay. Harvard Law School's David Wilkins says that generative AI has the potential to transform the practice of law. An article in The Economist stated that generative AI could radically alter the practice of law. And finally, according to Thomson Reuters' Future of Professionals report, 70% of legal professionals said they believe AI and Gen AI will have a transformational or high impact on the legal profession within the next 5 years. Muna, could you please share now the results of the poll? Thank you. It seems that overwhelmingly the audience agrees. So generative AI is here to stay, 94%, but we do have some people that think it's a fad. So it's very interesting to hear. Now, increasingly litigators are asked to make well-informed decisions and develop winning strategies. And at the same time, keep a big picture perspective within very short timeframes and with tight deadlines looming. I've been there. And AI can automate and simplify legal tasks, allowing the litigators to focus on high-value intelligent work. So I also agree it's here to stay. It seems that AI has the potential to revolutionize legal advice and litigation in general. Rather than wait for that big boom, should we be considering how AI can help us now? It seems AI can assist with legal topic extraction, document summarization, document review, legal research, contract analysis, drafting, entity extraction, and natural language query. And those are just some of the use cases. Before we hear from our speakers as to specific use cases where they think AI can assist in litigation, let's see what the audience thinks. Muna, could you please share the second poll question? We would love to hear from you. Among the stated legal work areas, where do you think AI can assist the most? Please choose the most common use cases in your opinion. Whilst we wait for the audience to respond to the poll, let's see what some surveys revealed. According to a Bloomberg survey of 456 legal professionals, 58% of the legal practitioners responded that drafting communication was an area where they have used generative AI in their practice. 53 was legal research, 42 was summarizing legal narratives, 34 was reviewing legal documents, and 15 reviewing discovery. This survey was not focusing on litigation, but it was a general one. Now, specifically to litigation, according to a research conducted by Ari Kaplan Advisors, studying and identifying challenges and opportunities for law firms involved in litigation support and case management, the most common use cases where AI was used to support litigation processes included legal research, document summarization, coding for eDiscovery, and drafting billing narratives. Sorry, I understand the wrong poll question was posted, so now we have the right poll. Sorry about that. Now, according to the same research, when considering using AI in litigation processes, 87% indicated that AI-assisted case management software is a competitive advantage. And according to the respondents, it will be transformative in document analysis, they said 100%, in transcript management, 90%, in chronology creation, 87%, and in case strategy, 77%. Muna, could you please share the poll results now to see what the audience replied? So interesting. We have 21% legal topic extraction, 75% document summarization, 58 document review, 58 legal research. We have a tie. Contract analysis, 50%, drafting, 43%, entity extractions, 12%, and natural language query, 25%. Raymond, seeing these statistics on AI use cases and the results from our live poll, what are your thoughts? Which specific areas do you think are important for litigation, case analysis, and preparation? And most importantly, why?
Yeah, I think these results are pretty interesting. I think they reflect what people are using AI for now. And if you look at, I think personally, legal topic extraction is important. I think they all are important, in fact, but legal topic extraction is important. And the reason for that is it gives you context around a case. Because you can be doing analysis of a case, and without context, you could be asking a question like, finding out if I went for lunch with James, for example. And let's speak. I might send him an email and go, all right, yeah, let's go for lunch. Speak about these Oracle shares. In that instance, that's a fact. Actually, there's two facts. I've sent him an email and I've also gone out for lunch with James. The problem is that in a case, in the context of your case, if you're looking at that in particular and taking that fact, is that relevant for your case or not? Well, if it's an IP case, then probably not. But if it's an internal case, or if it's a case around the insider trading, then that could be very, very relevant. So actually extracting and understanding the topics of the case can provide context. But I think what's important also to understand are legal workflows. Automating certain tasks in isolation doesn't mean that the legal workflow changes. For example, in litigation, the legal workflow revolves around lawyers reviewing documents, making notes and collaborating on documents, tagging documents, extracting key data from those documents and pushing this data into event chronologies, connecting events with witnesses and the source documents they come from, structuring this data into various groupings, building case strategies and stories, and ultimately building out the work product. What we're seeing is that with Gen AI, we can automate certain aspects of these tasks that make up the legal workflow, for example, like extracting events from documents or creating transcript summaries or spotting patterns in documents that are not easily found by humans. There are certain aspects that Gen AI is even better than humans at achieving. So when reviewing a transcript, humans tend to tire after a certain period of time, and the quality of the work can reduce as a result. All this is great, but it's not a substitute for humans. As I said before, humans are still needed to bring their own intelligence and experience into play. For example, checking that the analysis is correct, understanding what works as arguments in court, bringing in the context behind the case and presenting the case in the best possible light.
Thank you, Raymond. And James, any comments on what Raymond just said and in general, the results of the live poll from the audience? How have you seen AI being used in practice at your law firm?
I'd say it's cautiously. So we're testing things and playing around with new tools and new technologies and customizing and developing even our own within our own uh, incubator. We call it a group of technologists within our firm whose main goal it is to find ways for our lawyers to be able to do things more efficiently and help our clients, right? Across practice groups, so not just litigation. Um, so I'd say cautiously is in the fact that we're not only testing to see how well it does on its actual function, which a lot of people these days, because it is the hot topic, are purporting that their tool does everything and it's perfect. And you need to go in with your eyes wide open and test these things and see where you're going to see how accurate it is, and not only for just what task you're having it do, but the issues that can come about from it. And that would be things like not only looking at that, we need to look at what model it is, how it's storing the information that you're providing in there. Is your client's information going to be preserved there? Is it going to go into the cloud? Is it going to be who owns those queries and those prompts that you put in? Who, like all of those tasks and all of those things have to be analyzed as you're analyzing the tool for its accuracy, right? So that when you're consulting with your clients and your client says, I don't want the recipe for Coke to be uploaded into the chat GPT for you to write your brief. And so, there's just different things that you have to consider, and each client has different things that they're willing to do, where there's some risk but then there's a cost benefit analysis, right? So if I'm getting able to summarize a transcript with 80% more efficiency and 80% cost savings, is it worth it in that instance? Is that transcript, what's there? What's the risk in that transcript? How is that data being protected? Who owns the work product? Who owns the query? And is it discoverable? Like there's just so many questions around it that we have to analyze. So I would say for our firm, it's right now getting our hands around all of that and figuring out which tools we have and each tool we have. I mean, everyone's on the AI bandwagon. So it's not even like looking at even new tools. It's that every time I turn around, including lovely Opus, they've got a new function and a new feature. And I'm like, okay, well, what does this implicate? What does this work? And is it going to do a good job for our attorneys? Because people are going to be relying on this and the purported, effectiveness of it, but also what are the risks? And then how do we train, right? So that's the whole thing too, is we train our lawyers because, as Raymond said, this isn't replacing lawyers. So we need to tell them some of the risks and what they need to be doing. So even though you're adding 80% more efficiency and doing a summary of a transcript, so you just got to clean up, you do need to go look and see, is it capturing the key legal points that matter to your case? It doesn't always do that. It may be focused on something that wasn't really relevant to your matter. So you need to adjust that summary. You need to read it and focus on what your legal strategy is for the case and make that summary purport to it. So did it draft 60% correct? Probably. So you've got 40% more room to work to get it done, and you're going to be much more efficient, but it's still never going to be perfect. And that's where we have to, train our attorneys on how to use it. And we need to get our hands around it so we can tell them all the risks and the benefits so they can consult with their clients and decide whether or not they want to use it for those tasks and those efficiencies.
Thank you, James. Indeed, there are many use cases, but as you say, the cost and benefit analysis is quite important when you're using any new tool for that matter, not just AI. So let's now move to another hot topic when it comes to AI in the legal sector. What are the risks? And I think this flows from what both James, you and Raymond said. What are the risks of using AI in legal work, and how should AI tools be evaluated? Some of the risks feared by legal practitioners include data protection, security and privacy, hallucination and accuracy, model bias, change management process and how to deal with the process of implementing a new AI software, job security and fear of being replaced by AI, and intellectual property concerns. These are just some of the risks, and we've seen some questions coming before the webinar where they're touching on those risks. James, in your experience, which of these risks are highest on your list and why? And most importantly, what are you doing to protect your law firm and your end client when it comes to these risks? You told us about the cost and benefit analysis, but we'll want to hear a bit more about what you're doing to protect the law firm and the clients.
What we've done is we've implemented some strict policies about what can be used, and a governance policy where people need to seek out permission, right? Not only from their client, but also from the firm itself, the group that we have a panel that assesses these tools. So they're not only looking at data security, they're looking at the contractual language to see who owns what, where data is stored, how long until it's deleted, all of that sort of stuff, which is really important for your client's data. You have confidential information. You might have personal healthcare information. You might have PII. There's so many things that can be residing in a pool of data that you receive from your client to litigate a case or to handle an internal investigation. So where that data is and who owns it and how it's being used is really important. And you don't want to just, it's just like using Google Translate. You throw in a client's document translated in there, Google owns that, and it can be a part of their learning tools and in their system. So that is not something you want to do, right? So you have to be careful about your cloud-based tools. So it's educating our lawyers and also figuring out these tools so that we can come to them and say, we're happy with these policies. These are exactly what you need to understand. The data is preserved. It's in our environment in Azure. This is the model it's using. We own the prompts according to the contract. It's deleted after 7 days. It can't be, all of that sort of stuff, so that then we can educate the client, say, can we use this? We think it's going to add efficiency and value. So it's looking at the security, but looking at the ownership, all of that sort of stuff, and then the accuracy, right? So we want to see where things flourish in one sense and in another they don't as well, right? So all AI and all of this stuff is going to add some efficiency and it's going to add things better, but you need to walk in with your eyes wide open. And so you can say, okay, I know this is going to get me 40% better, whereas this one's going to get me 90% better. And you don't just rely that it's always going to get 90% better. And then you have a 40% work product going out to the court or to a client or to, things like that. So those are the concerns there. So it's getting our hands around it and then being able to educate our lawyers and then decide which cases it's right for. But it's also looking at the legal world. We have to stop right now. This is so new. So I'm consulting my lawyers to slow your, as I say, slow your roll, and it comes to getting the excitedness with like doc review, right? So if we're using it for doc review, we've always used AI. I mean, not always, but for a long time, we've used continuous active learnings and algorithms and things to make things more efficient and to do QC and all of that sort of stuff. But now with generative AI doing that sort of thing, you're building a prompt, and your prompt is essentially your review protocol, your case strategy. It's what you're looking for, and you're training lawyers on what to seek in their documents and how to build out the case story and things like that. And it's a new area of law. We don't know. Is this going to be something that's discoverable? Do we have to discuss this in a Rule 26F conference? Is this, there's a lot of risk there still right now. So to me, I'm like, let's play with it. Let's see the benefits, and maybe let's find ways we can use it if we think there's going to be a lot of efficiency in a minor sets and doing things there, but not in something like that. We don't know yet how a court's going to hold, if it's going to be discoverable, and there's risks there. So I'd say it's the risks, the data security side, who owns the data, the prompts, and then the discoverability side of what's being used. Is it being just used for internal work product, or is it doing something that's making a decision in discovery where you might have to validate it and prove it to a court? And then what does that mean, right? So it's just making sure everyone understands all of those, that we're discussing them, and that we're making thoughtful decisions with our clients on the use of AI.
Thank you.
James,
I
can I
think
ask
some
you a
of the...
question about that? Sorry,
No,
Nadia.
go ahead.
So the discoverability, do you see that being as an issue when you're speaking about disclosure? Do you see that more an issue around e-discovery tools as opposed to case management tools in general?
Definitely. Like case management tools is internal work product, so it isn't making a decision. It's adding things like data extraction, pulling your entities, doing things like that you would need to do to make things better, more efficient in your case outline. So that's different. That's your work product internally, and no one else. It's not subject to the rules of discovery in that aspect, right? So if you think about what you have to do when you're doing a doc review and a doc production, you're negotiating with the other side, and at the beginning of what documents are going to be the most responsive to the claims and defenses in your case, right? So if you're allowing a software to make those calls, then it's how do you validate that, and how did you program it and do that? And so if you think of the old AI, I'm calling it old, but it's not old, but Cal, you would go through and you would run your review, and then you would negotiate with the other side usually, or the government or whoever is doing it, and you decide the recall rates, you decide all of that sort of stuff that's going to happen, and then you get to there and you validate it. So with AI, that's not that way. It's a prompting, right? And you're writing it, and then somebody else can disagree. And that's the whole point of law right now is, I mean, in litigation is the other side has a completely different theory on a case than I do, right? So, or than my team does, right? That's why we're fighting and we're in court. So the way they would draft a prompt is way different than the way I draft a prompt. And that is going to be, that prompt is what's making the judgment calls. So that to me is still up in the air. I don't know what it's going to be. And with courts and so do you want it? That's a risk. And that's where you've got to weigh it in doing something like on a doc review basis, on a big doc, I mean, on a massive doc review. The good thing is though, I mean, not the good thing, it's kind of slow rolling. As fast as everyone's talking about generative AI and using it and all of these things, it's still a little cost prohibitive in the sense of a massive doc review. That's just a lot of data going, into the cloud and using a ton of tokens to be blank. So it's still a little cost prohibitive at this point. So I think it's getting better. It's come down so much in the last 2 years. It's insane how much cheaper it's become, but it's still not at that level where people are like, oh, well, I'm going to use it. And then if they argue with me on the other side about the process, I'll just put in doc reviewers and just eat the expense. It's not a little expense at this point. So.
Yeah, indeed. So yeah, there is a difference between discovery and disclosure and document management systems. And the risk you mentioned, I'm sure a lot of legal practitioners, they keep them awake at night thinking of this, especially because everyone is talking about AI now, and I'm sure they're thinking of using it. Thank you, James. So let's see some more stats and discuss. So respondents to the Brian Case Leighton Paisner AI survey, this is an arbitration survey on the use of AI in international arbitration, highlighted concerns including AI hallucination, where 88% of the respondents were very or somewhat concerned. Breach of confidentiality had 87.5% concerned, and deepfakes had 86% concerned. Raymond, data protection, security, and privacy implications of an AI system seem to be very high on the priority list when dealing with AI. What's your advice on how to keep AI secure? Were these risks taken into account when developing the Opus 2 AI tool?
Yes, to answer your last point, they absolutely were. I think the current iteration of Gen AI has potential risks around both security and hallucinations, as was on your slide there. As the technology, it's actually engineering that wants to be helpful, and it wants to respond to the questions you ask or the tasks you've been assigned, or the summarization that you've tasked it to provide. So Gen AI models, if you understand how they've been created, have been trained on a vast amount of data. So as part of this training process, these systems learn facts about the world. We call it the inherent knowledge within the Gen AI. So with the data that is taken in, it's extracting some facts about the world, and then that becomes part of its knowledge set. What is really important is that that inherent knowledge is not used within cases as facts in its training. These facts could be wrong. And the model can actually confuse facts from within the case, or information with the case, and facts that it's learned from its training. So when we engineered our AI, we made sure that it could not use its inherent knowledge when answering a question. So for example, if I asked the AI, what is dioxin, from maybe a transcript or a document I have, it can't respond by giving you the definition of what dioxin is unless it actually appears in the transcript. So we've locked down the AI to never use that inherent knowledge. And the same technique minimizes the risk of hallucinations, as it cannot respond with information that doesn't appear within the documents in the case itself. And accuracy is one thing, but no matter how accurate the base model, there will always be issues and errors. James was speaking about 40%, 60%, 80% accuracy as an example. This is same whether it's built through AI or by humans. There's always going to be inaccuracies. When we manually analyze documents as humans, we always provide the sources of our conclusions, or can provide the sources of our conclusions from the documents themselves. And what we've done when we were developing our AI is replicate this. Therefore, if you ask it a question, you don't get just the response back that you've got to then trust. What we then do is provide all the sources within the documents and exactly where in the documents the AI has found the information when it's come back with the responses, either to a summary or to a question that may be asked, or extraction of data for a chronology, for example. This means that you can always check the accuracy of the analysis, which is really super important within the litigation.
Thank you, Raymond. James, any comments on the references accuracy that you wish to respond to or comment on?
I would say that I completely agree with Raymond, and I wouldn't use a tool that didn't do that. So and there are several out there, and not even in the case management space, just in general, that will just respond to a question. And that is, as we've seen with some of those embarrassing court cases where it just created cases and things like that. You have to be able to cite check, right? That's why we always know there's a job for lawyers, right? So we have to not only come up with the legal theories, but we have to go through and validate everything that we're submitting to the court, our discovery responses, our doc review process, all of that sort of stuff. So to me, I find it essential that you not just trust these tools, even though they may be highly accurate, depending on what you're doing. That's your job, is to go through, and our lawyers will always be busy because they're not only drafting the prompts and training these tools, they're also validating them on everything that they're doing. It's just making things more efficient. And that's what we need. If we see, like, over time, I remember when continuous active learning first came out, everyone's like, it's a black box. It's so scary. This algorithm's making a percentage call on the responsiveness on documents, and lawyers are going to be out of work and blah, blah. But it didn't happen. What actually happened is we had to validate it, we had to use it, but we have 1,000 times more documents per person now than we ever used to. So thank goodness we have that. There's not enough lawyers in the world to review all the documents that people are producing these days. Like, my email box used to be like 1,000 per month in 2010. It's like 1,000 a day now. So it's like, there's an explosion of data, and now we have Slack, and we have our text message and WhatsApp, and so many different data sources coming at us right and left. So we have to be innovative with the technology and accept it, but use it smartly. And that's to me, using it smartly is validating your prompts, validating its responses, checking to make sure that it's actually getting the theory of your case and your investigation accurate.
Yeah, indeed. And you cover one of the other risks that lawyers are concerned in terms of AI replacing them. So thank you. And as you mentioned, there were some high-profile cases where using AI went completely wrong. I'm sure we all have heard of them. And that's when lawyers used it to write legal briefs, only to finally discover that the AI just made up the cases that didn't exist. And the lesson to be learned from these cases is not that they always are reliable and work best, and that we should stick to those, which I've heard some lawyers say. But I think that lawyers need to be in charge and use AI tools to assist them, not replace them. And as James, you said, it's all about efficiency. Use them to make you more efficient, not replace you. AI is simply a tool for lawyers to use, and they should take an active role in developing these tools and train on how to use them to their advantage. Lawyers should remain responsible for their research, their arguments, and representation. And I strongly believe that they should always review the work produced by an AI tool, as they would if anyone of their associates or whoever prepared it. Now, AI has a transformative potential. I think we all agree. And I believe both lawyers and vendors have an important role to play in this transformation. And initiatives where lawyers are partners in the process in developing AI tools ensures the tools developed are fit for purpose and they are not to be feared. It also ensures that legal practitioners understand better how it works and are trained on using it, making sure it is used in the right way. At Opus 2, AI Labs was put in place to allow legal practitioners to test the AI features and be part of how they are developed by providing their feedback. Raymond, how did the participation of law firms shape the development of the Opus 2 AI tool?
AI Labs was hugely, and still remains hugely important for us. When we started our AI program, we asked our clients what they wanted from AI. And there were certain themes that emerged. They wanted a single place to analyze all the documents that can be used at all stages of the litigation. A single source of truth for the AI, in other words. This stops firms needing to analyze the documents several times for different stages of the case. So for transcript summary, for example, or for extracting entities from a document, or for generating some work product, etc. And this also reduces costs, which is important because there is a cost associated with analyzing documents. So if you can do it once and use it in several areas and several work products, that's a huge benefit for our firms. It also means that the analysis is consistent throughout the case, so you're not getting completely different results using different analytics tools or Gen AI tools or prompts, etc. They also wanted AI to enhance what lawyers already do. They didn't want to replace their existing workflows, have the lawyers have to use a completely different new workflow that they weren't familiar with. And lastly, they wanted us to make performing tasks take less time, be more efficient, and find patterns in documents and data that are not as easy to find when there's a large volume of documents. So we took these requirements and defined a set of principles that we use to this day when building out our AI into how our case management products work, namely to augment and enhance what lawyers do, enable trust. And I think we've spoken about trust briefly, but how do lawyers trust what they're getting back from the AI, and then being able to cite, as an example, citing the references, those things build trust with the AI. Allow lawyers also to remain in control. So do not create work product on their behalf, or let them actually be able to change work product when it's being created. An example of that would be when you're maybe extracting events from a set of documents into a chronology. If you do that without any control, if you have 20,000 documents, you could quite easily get 200, 300,000 events. Because there's events everywhere in documents. So you need to provide, one, the context I was speaking about before, but also enable the control to say, I'm not going to populate a bunch of irrelevant events, because if you go through 200,000 events and say, oh, well, 95% of these are not relevant, taking out 190,000 events from 200,000 events is not something that lawyers want to do. And lastly, it needs to be secure both from an architectural and a data perspective. So having these set of principles meant that when we designed our AI right through to development and right into the production, our products always align and always have aligned and always do align to these principles. The next step was defining the concepts we wanted to add into the product, build these out, test them with clients, ensure that our assumptions were correct, and iterate until we have something that not only solves the business problem, but allows our clients to trust the results and adds value to the legal process. So this is what our AI Labs provides us, and the benefits are for both Opus 2 in developing class-leading AI, but also our clients in getting the best case outcomes for their clients.
Thank you, Raymond. It seems that law firms can shape the evolution of AI tools with such initiatives. James, how is your firm working towards being innovative in the evolution of AI tools?
I spoke how we have a dedicated group that focuses on those, and I'm a part of that group, and lots of people in various practice groups are part of it. So we analyze tools overall for the firm, but then we take the initiative, for instance, to be a part of AI Labs. So it's important for us to be involved in these test projects so we can help develop and formulate these tools. All too often, technologies these days I find are built by softwares are built by technologists, right? So they're not built by lawyers. And so when you look at the way they're set up and they're just not logical to a lawyer. So they're not adding efficiency, they're causing confusion. And then they get those people who are like, I just don't want to use it. I hate technology. Keep it away from me. it could work for you, but it doesn't work for me. And so you don't have easy adoption. And that's one of the hardest things as somebody who helps run some technology in my firm. You need the lawyers to adopt it. I'm not going to spend all this money on it if it's not going to be adopted. And so you can say it's the best thing in the world, but if it isn't developed in a way that's intuitive to an attorney, and then the way that they work in the general practice, then it ain't going to be adopted and it ain't going to be used. So to me, it's important for us to make sure that we have not only our technologists in-house analyzing the tools and looking at the tools, but also to be a part with the lawyers of what's the workflow? How do our lawyers work? What are they doing on a day-to-day basis? And how can this tool be drafted to make it easier for them or built so that they'll actually use it? So it's intuitive, but it's also adding efficiency, right? So those have to go hand in hand. And I think that you have to have a lawyer or somebody who actually does this day to day there to give their insight to the technologists as they're building it. So that is important. And I think that's why we take the initiative to try to be a part of these test groups in both review tools and in case management software and things like that. So the ones that we already own are being built in a way that we can use them and also train our attorneys and sell them on using it.
Thank you, Jim. I think it's important, and I would be very interesting to see if the audience has participated in such initiatives. Muna, can you please share the audience poll? Have you participated in some sort of testing program with an AI vendor like beta testing? If you could reply, it would be interesting to hear. We'll wait a few seconds and then we'll share the results so we can discuss them. Muna, maybe now you can share the results. Okay, it seems that 27% of our audience has participated, but 73% has not. So I think there seems to be room for more participation from legal practitioners. And as Raymond mentioned, it's very important to set those principles and set them at the beginning. And as you, James, said, it goes hand in hand, helping shape those AI tools and making the lawyers comfortable in using it. So it seems there is room for people to participate. Was it surprising, James or Raymond, in terms of 73% of our audience not having participated in such initiatives?
No, I think that there's most lawyers, at least in my opinion, most lawyers and people as a whole, which it's part of the legal profession, we're slow to adopt, and because we're cautious, right? We're a risk analyst. That's what we do. We analyze risk, right? So I think to me, it's not shocking that people would be like, I'm going to hold off for just a little bit on this and just see how it panders out, because it's been a buzzword, and we all know that a buzzword has a habit of fading sometimes too. So I could see why people would be like, I'm not going to spend my time on this yet, right? So
Yeah.
I think that it's going to happen a lot more. I just feel like that with the legal profession in particular, unlike business is adopting AI like crazy. They're doing it cautiously, and and hopefully with their lawyers consulting them on all of these risks we talked about, but they're adding efficiency in a lot of different ways in their business and in their finance and in how they're tracking their shipments and their technology and their workforce productivity and every other thing known to mankind. So they're a little bit faster at it than we are, and I'd be shocked if I think the poll would be reversed if it was business, but in law, I'm not surprised.
Mm-hmm. Thanks. Anyone, any comment, or should we? No.
Yeah, James is probably right, but I think that my experience has been we've been inundated by clients who have wanted to use our AI labs, and we've been restricted in the number of clients because it's a big commitment on AI labs for us, because we are engaging with clients, we're getting a lot of feedback, we're iterating very, very quickly, and then we're providing updates to clients, and then we're doing that process again and again and again. And so I think word has got around with our client base, and the initial people the initial firms which were using our AI in our AI labs environment. There's more and more and more of them are coming, almost on a daily basis, asking, when can we participate? Because it's not just about this the existing iteration of AI that's in our product right now. They're wanting to see, well, what's coming next? How are you doing this? How are you answering this problem, etc. And they want to open up that conversation. So for us, I think I'm a little bit surprised by this poll because from our experience, as I say, we've really had such great interest in people wanting to engage with us on the AI Labs.
Thank you. Research suggests that all jobs, including the legal sector, will be affected by AI. I think it is essential that law firms keep up with the changes. For instance, law firms might find out that clients may not want to pay lawyers for what AI can do more cheaply. Moreover, lawyers cannot advise clients about a world they do not themselves understand. Clients will be dealing with digital transformation in their own sectors, so using AI tools not only allows the law firms to streamline their processes, but also to have a better understanding of the challenges faced by their clients in this area. And as James suggested, in his opinion, in the business, there will be a lot more people adopting AI, so it's important for the lawyers to understand it as well. I would be interested to hear from our audience on this topic. Mona, can you add the last poll question? Do you think that if you do not use or start using an AI software, your competition will perform better than you? Now, let's wait a few seconds. Mona, maybe you can share the results. Okay, so we have 84% thinking that most likely their competition will perform better than them if they don't use an AI software, and 16% think that it's not likely. James, do you agree with the responses from the audience?
Yes, I think anything that, lawyers' time is very expensive, right? So, and it's the legal process in general is just expensive. Litigation is expensive. So anything that will lower those adds efficiency and keep those hours down, clients are going to demand, and they already do. And as I said, I've already gotten several surveys from clients asking what we're doing and what we're using. And it's not necessarily out of a risk, it's more of a cost-benefit analysis saying, are we being proactive instead of reactive with their legal tasks? And that's important for us to show that we're being proactive. So I definitely say most likely would have an impact if we weren't trying to get ahead of it.
Thank you, James. Raymond, what about you? Do you agree?
Interesting. I think that, how to answer? You can build a car by hand, and at one point, all cars were built by hand. And with hand-built cars, you get pretty much everything you can get from a car built in a modern car factory. But the fact is that with modern automated manufacturing processes, the majority of cars are built in factories. Therefore, building cars in factories has a competitive advantage over building them by hand. Another example is when eDiscovery tools came on the market. They had a competitive advantage over manual review. Hence why, in all but the smallest of cases, these tools are used. And it's the same with AI. Using AI in case management provides huge advantages to law firms. As James already mentioned, but AI will be integrated into almost every aspect of case management workflow. And if you're using case management software in the next few years, then you will be using AI, whether the user realizes the feature has AI embedded in it or not. And finally, I actually just saw a question from someone in the Q&A, and they mentioned about large law firms as opposed to smaller law firms. And speaking to actually in international arbitration, I was speaking to, and I have spoken to a number of those institutions. And what they say is that what they see with AI and a trend is what they call democratization of litigation, where smaller law firms may not have the resources to be able to push and do a lot of work with regards to the analyzing the case strategies, because they're spending a lot of time doing, a lot more time-consuming tasks. If you substitute a lot of the time-consuming tasks with AI, and then you utilize that time to then maybe look at the case strategy, or you're working on work product, then the advantages that the biggest law firms have may be reducing in the future as well. So it's just something to be aware of, that it's not just this can be something that only the largest law firms. I see there's advantages from the smaller law firms right up to the largest law firms in using AI within case management.
Thank you, Raymond. You seem to be in a hurry to engage with our audience in the Q&A. We are just 2 seconds and we're there. To conclude, generative AI holds huge promise in transforming various aspects of litigation. A collaborative partnership between legal practitioners and generative AI systems, I think we all agree, is essential to take advantage of the potential of such technology in a responsible manner, as both James and Raymond mentioned. Not embracing AI risks law firms becoming obsolete, but law firms that get it right and use it to their benefits stand to reap the rewards. And it seems that our audience thinks that as well from the last poll question. And now we've reached the final section of this webinar, which is the Q&A. We have some time to deal with some questions from the audience. Keep on posting if you have any other questions, and I will ask Raymond and James some of the questions. So there is a question that says, what strategies have been effective at driving adoption of AI tools? James?
What strategy? I mean, to me, for adoption, it's to do the analysis, right? So to get people to adopt it and use it, you got to do the analysis and come up with how it works so that you can go sell it, right? So that to me is where we're going to get the adoption and use of AI tools, is for me to create the comfort, show how it's going to add effectiveness and efficiency, and make their lives easier, right? So that is important for me as a technologist within a law firm. It's my job to help our attorneys be more effective and more efficient, and I need to get them to adopt these tools. And the way we do that is for us to learn them, make them feel comfortable, and be able to tell them all the pitfalls and all the great things about it, and then show them how easy it is of use, and that there's low risk as long as they're doing these certain things.
Thank you, James. I think the question that Raymond very eagerly answered was, how can small and medium-sized law firms leverage AI? And there was another comment when we were discussing the beta testing, where one of the participants said that maybe only larger firms have the resources to beta test. Anything else you would like to comment, Raymond or James?
I actually think in beta testing, I think it's something where there's not a huge, you get out what you put in, and you don't need to have a dedicated team working, especially in our AI labs. We have people who come in, see what's happening, and spend maybe a few hours there with some firms. Other firms, they have got a wide variety of people coming in, from lit support and right up to senior associates and even partner level. So I think it's something that I would definitely recommend that you join a beta program, even if it's so that you can see with your own content how it actually works, and how your lawyers can build into their existing workflows, and they can trust and also control the AI and not have it just run away with itself.
Thank you, Raymond. There is a question that says, do we need to be concerned with hallucinations with AI? And what is the standard error rate? And how do we mitigate against mistakes? So we've all seen that hallucination is something that people are concerned about, and we talked about it. But maybe let's start with James. Is this something that is of concern? And how can you mitigate against mistakes? And I'll come to you, Raymond, as to how we mitigate, even though you've touched upon this during the webinar.
I'm just gonna go back to what I was talking about before. So that's why there's always going to be a job for lawyers because nothing is perfect, right? So, and that's where you need to assume that it's not going to be perfect, and you need to assume that you still need to go and review everything that all the work product that these AI tools are putting out, right? The goal is it's just to make you more efficient, but you need to review it, and you want to only trust a tool that's going to give you the sources of its analysis, right? So that's where it's important when you're looking at it that it's not just giving you an answer and you're relying on it. It's giving you an answer. You validated it by not only reading it and say you agree, but you're looking at the source it's relying on to come up with that fact or that answer or whatever it's being used for, or even that entity extraction, right? You could ask it to pull out entities, and it could be pulling out entities from a contract you put in 3 years ago. As you know, you really just got to double check and dot your I's. But that is, to me, it is something that's important, and it is something you need to validate. And that's where a lawyer needs to read every single thing that's there. It's just that they're not going to have to draft it all themselves, right? So it's going to be, you still got to read it, but you don't have to write it.
Thank you. Raymond, any
Yeah,
comments?
I do absolutely agree with James. I always use the analogy that if I were asking a question, a question about my favorite football team, and I put it into a chat bot and I get the answer, and I say to my friend, this is the answer. If that turns out to be wrong, then I might have lost a bet with my friend. But in litigation, if you actually do that and you base a legal argument on it, then there can be, it can have major consequences in your case. And, people speak about hallucinations, but, it's kind of interesting because you, with humans, we actually don't use fancy terms like hallucinations. We use a term like a mistake. And humans have got techniques to make sure that if mistakes are made, we can mitigate from those mistakes or find those mistakes before we actually use them within our case. So if a partner asks associate, about their analysis, the associate should always be able to say, well, this is the data that I got, and this is where I got it from, and this is why I came to that conclusion. And exactly the same thing should happen in the AI, and this is what we do within our AI. We mimic the human approach to analyzing and making sure that we have got accurate information. We actually call this our white box approach, where there's full visibility as to what the AI has done and how it's come to the conclusions it's come to.
Thank you, Raymond. I think we only have time for one more question. So let's see. There's a question: how can law firms and lawyers ensure that client information is still being protected while using AI? I think both of you touched upon this. Is there anything else you want to highlight on this?
I think that, oh, sorry, James.
Go ahead.
Well, I think this is a great question. The security model we use to ensure that the client information is secure within our case management system also applies to our AI. And we actually use 4 principles when we use this within our case management system. First is that no case or client data leaves the law firm's instance. Therefore, case documents don't go out to a third party. And this is where James was speaking about, sending out the recipe for Coke. That just will never happen. And secondly, the analysis we perform is very, very case specific. This means that when we do the analysis of the documents, we store the results within the specific case. And there's no case data that can go from one case to another. So you can't ask a question in one case and get information from another. Thirdly, we only allow our AI, as mentioned before, to respond to information from the case documents itself. So it can't use it, as we term, the inherent knowledge when responding to questions. And finally, we do not train our AI models using our clients' information. So again, that's the security. So I think these 4 principles are hugely important to build confidence that clients' data will be secure. In fact, the client's data with AI within our technology is as secure as all of the case documents and data for each case. And we would definitely recommend that if you are reviewing any product on the market that uses AI, then you make sure that they adhere to those four same principles.
Thank you very much. In the last few seconds, James, anything you want to add on this?
I mean, I'd say that you just need to do your due diligence and make sure you're contracting like you would with any tool that you're going to be using where you're going to be storing client information, right? So there's several principles in there. You need to know who's storing it, who owns it, how it's being used, what model they're using. All of these things are things to ask about and to make sure that you're putting contractual provisions in on who owns the data, how long it's going to be stored, who's going to delete it, when it's going to be deleted, all of that information that's important because you need to make sure you own it and your client owns it and not the software provider.
Thank you. I would like to thank both James and Raymond for their time today and their insightful comments. Thank you very much. I would also like to thank everyone who attended. Thank you for your time. Thank you for your questions. And thank you for answering all our poll questions. It was very interesting to hear what you thought. Thank you and have a lovely rest of the day. Thank you so much.
Thank you. Bye-bye.
Bye.